All right, we will call the meeting to order at 5:55. And Doug, if you can just note the roll on your minutes, and then for the appearance section, if there's anybody here to appear about an item that is not on the agenda, let me know. Seeing none in the room, seeing none up here, but hang on. Mike or Mr. Fritz, are you able to hear us?
Yes,
Okay,
thank you.
I just saw your chat. Apologize, we ended up getting started a little late. There was some traffic delays, so we're good to go.
Aldo, would you mind starting the video on that as well? At bottom left, please. Thank you.
All right. So the meeting was already called to order. We noted the role appearance section. We identified that there was nobody in the room that wanted to appear on an item that was not on the agenda. Mr. Fritz, you're the only one on Zoom. Are you here to appear on an item or to observe?
I'm here to observe, and I guess depending on how things proceed, I may have a comment.
Okay, and is your comment regarding an item that's on the agenda?
Yes,
Okay, so that would be during the public hearing section, so I'll likely start with you when we get to that point, and if there's anything that comes up during that public hearing section, just use the raise your hand function. I'll do my best to keep an eye on it, okay?
okay.
All right, so we can close the appearance section. We'll move on to item 4, which is the approval of the October 17th, 2024 minutes. So a motion.
I move to approve.
I'll second.
All right, any edits or changes? See none, all those in favor say aye.
Aye.
Opposed? Minutes have passed. We are on item 5, which is a public hearing. This is pursuant to the city code of 175-12A for George Kinsler and Ramona Roy. 4539 Winnicott Road, and they're appealing the decision of the city buildings inspector dated January 3rd, 2025 and January 13, 2025, denying the building permit request to repair, replace, remediate, replace, and remodel existing improvements and remove first and second floor above floor deck and foundation, maintaining the masonry fireplace. This is case number Z001, 2025. We have some comments for the public hearing. Typically, I ask people to give a short presentation on what is it that the public hearing is about, because sometimes the content item that's read, not everybody has a good sense. So, Mr. Fleming, yeah. I'm not sure if you're able to give a small presentation on what it is that you're asking to have. Sure. We read it, but it's always good to hear from somebody, and then we'll go for a public comment. All right.
I'm attorney Matt Fleming. I'm here to represent George Kinsler and Ramona Rohr. Basically, what this appeal is about, we've got a existing home, a lakefront home that is non-conforming as to the lakefront setback. It is an existing legal non-conforming structure. It had been issued a raise order because most of the improvements, particularly the roof, are in some substantial disrepair. There had been some litigation about whether any of that whether the raise order is reasonable in efforts to maintain most of the structure and repair the existing structure. That was decided against my client. So now the plan is to hopefully rebuild upon the same spot. So after that litigation ended, my client applied for a building permit, followed by a demolition permit, which I think was probably implied by the building permit, which was to basically tear down the entire existing structure, try to maintain the existing masonry fireplace, and rebuild on the same foundation. That permit request was denied, citing, as indicated in your yeah, I think you have the building or the decision of the building inspector in your packet. The first reason that was denied was based upon section 480-40, parent or A of your zoning code, which indicates a general rule that any existing building or structure may be continued, although its size or location does not conform with lot width, lot area, yard height, or other dimensional parking, loading, access, or site performance standards, provided shall not be extended, enlarged, reconstructed, or moved or structurally altered. That was the portion that was cited. The ordinance, however, goes on to say, except when required by law or order or to comply with such provision, or where there would be no additional encroachment on zoning regulations. And because we are planning on building on the same foundation, there will be no, additional setback encroachments. It's essentially to build in the same exact footprint. And so what was proposed to be done was legal under the city zoning code. So the main reason why it was denied was simply an error in reading the ordinance. The second reason is because of the raise order. Now, the raise order has gone through court. The courts have indicated the raise order was reasonable. However, what we are doing is largely removing all of the existing dilapidated structure and reconstructing a new structure. The reason why this is important is because to be able to use the new foundation or the existing foundation is because it's important to keep the structure where it is. It's a lakefront property. You have a ridge, as is the case in a lot of lakefront properties. The current house is seated on top of that ridge, just like just about every other house in the area. That's where you can best see the lake. You have an existing foundation rather than dig it all up, have to pay for digging it all up, and then re-pour a new one in a different location where a new site would be less desirable and less valuable. Just simply doesn't make any sense. There's also an existing tunnel that goes from the basement to the boathouse. That's a pretty unique feature. It's our understanding that if the city goes through, that they would dig all that up as well. We're seeking to preserve that and have that incorporated into the new structure. We don't believe that there's any structural problems with that. And that tunnel is also particularly important because my client is disabled. And the tunnel, particularly in winter, would allow him to get from the house to boathouse and be able to be lakeside rather than have to negotiate a big hill with lots of obstacles and so forth. So long and short of it is what we are asking for is to simply do what is allowed by the city ordinances, and that is the thrust of our case.
Yeah, if you want to present from the city side. And this is with the intention of providing some additional information.
Yep.
So that way, when we're going through for public comment, people know what they're commenting about. So you're not commenting about things that we're not actually considering tonight.
Sure. So good evening, Danielle Tierney. Most of you might recognize Bill. I've been handling this case. It's been going on for quite a while, actually. And we're here, though, to discuss denial of two permits. The first permit was, as read off in the agenda, to rebuild. Although there was a representation that it was on the existing foundation, you're going to see that actually there was some expansion and some additional encroachment. So for the citation to 480-40 was correct, while the entire statute, or excuse me, the entire ordinance wasn't cited in the letter. because there would be additional encroachments on zoning regulations, the ordinance applies and the structure cannot be reconstructed or structurally altered. There was a discussion about the raise order. You're gonna hear about the raise order. There is a lawful raise order that was issued by the city of Monona to raise the property. Raise is not simply to take things down to the foundation. Raise is a defined legal term. The building inspector did an inspection, coming up on 3.5 years ago of this property. That's how long this has all been going on. The raise order was issued. There's been extensive litigation about the raise order, and exactly what the applicants were or are requesting to do to rebuild, to keep the foundation, that was all argued in the court. So as it stands, there is a lawful raise order that was issued by the city that was deemed reasonable by the circuit court, and the circuit court ordered that the raise order should go through and that the city can go onto the property to raise the property. That was litigated up to the Court of Appeals, and the applicants then also petitioned the Wisconsin Supreme Court to review that decision. Supreme Court turned it down. The stay, there was a stay imposed on the raise order, so like a pause was issued. That was finally lifted in December of 2024. So about 2.5 years after the raise order was issued. And the city has taken steps to act upon that raise order. So issuing a permit in this case it was lawfully denied because the proposed applications or the applications for the proposed work do not comply with Monona ordinances, and similarly do not comply with lawful orders, namely the raise order. So you're going to hear some information about that. And we think that the BZA should affirm the denial of the permits.
All right, now on to our public hearing items. Mr. Fritz, are you choosing to speak on this matter?
Well, I can offer just a couple observations in addition to the letter I submitted, and I assume that's been received.
It's been received, yes.
Okay.
Did you want that letter read, or are you
Well,
just
I'm-
going to comment on it?
I'm assuming that the members of the zoning board will be able have read it, have reviewed it. Is that, or do I need to read it?
You would need to read it. It has not been sent to all members.
I see. Okay, right. Well, bear with me. Sorry.
Yep. Nope, we hear you.
Okay, so let's see, I'll just condense here a bit. I wrote to express my opposition to the variance request submitted by George and Moni regarding their property at 4539 Winnequa Road. We are adjacent neighbors to the east of the property. The petitioners vacated the house in 2007, I believe, and the structure has long been a hotel for raccoons and possum who frequently prowl our patio and raid our compost bins. The garage collapsed in August 2016, and the house has continued to deteriorate, creating both an eyesore and a potential safety hazard. We agree with our neighbors, Brandon and Emily Goatsman, that allowing the applicants to circumvent the court raise order by attempting to rebuild on the same foundation will only prolong the current issues and set a concerning precedent for other non-conforming properties in Monona. Maintaining the existing foundation and the chimney should not be sufficient grounds to circumvent Monona Ordinance 480-40, paragraph A, I believe, because pursuing the homeowner's plans as proposed would result in material structural alteration and subsequent reconstruction of the house on a non-conforming footprint, which is not allowed for lawful non-conforming structures under the ordinance. Further, since the house has not been occupied since 2007, the non-conforming structure is no longer permitted under Article 8, non-conforming uses, and I have a citation of the section 466-30B, paragraph 2 of the Monona Ordinance. I urge the board to reject this variance request and uphold the city's prior decisions regarding this property I would just add that it's regrettable that we're meeting here today on this property on several fronts. It's a predicament entirely of the applicants making, since they have chosen to allow the structure to deteriorate after vacating it some 17 years ago. It is also regrettable that they have pursued this litigation and cost Monona taxpayers a significant expense. I also urge the members of the Zoning Board of Appeals to cast a skeptical eye toward the claim in Attorney Fleming's letter regarding the integrity of the structure's existing foundation. The petitioners have employed dubious claims as they contested the raise order in their 2023 Circuit Court appeal of the order. The petitioners included an affidavit that pegged the cost of raising the property at $167,800. I have shared a demolition proposal with Mr. Plowman I obtained for the property from Meinholz Excavating, a firm with considerable experience demolishing lakefront houses in Monona. Meinholz agreed to raise the site for $30,000. That's the extent of my comment.
Thank you, Mr. Fritz. And I have a few sheets here. If there's more people that wanted to speak, just let me know after I get through the sheets and we'll fill one up. All right. So Jeff, I have you up first. You're at 4809 Lee Road, number 310.
That's correct. Yeah, I'm just here to support George Moni's
Okay.
decision there. I'm a former Monona resident, by the way.
All right. And then we have, it's Toby and Jennifer, right? Janelle. Kinsler, did you guys want to speak or just?
I would say that I think it's, as living in Monona as long as we have 16 years. My kids, when they were little, skied there. We've had family dinners there. And it would be a shame to have that property teared down. It's been in the family for a long time. And we would like to continue that down our.
Just similarly, I guess generally as a citizen of Monona, I find no practical purpose served by what Attorney Tierney is offering. Attorney Fleming is offering that the home can be reconstructed and rebuilt in the same footprint without any adverse impact, and it really does serve no practical or public purpose to go along with what Attorney Tierney is arguing. It defies logic, candidly. And I unfortunately brace at Mr. Fritz's self-serving letter. My guess is that he's pushing very hard for this because a pushback would only enhance his view. But that serves him. It doesn't serve the city. And even though I'm living on the other side of town, if something like this falls down, it concerns me as a citizen of the city, and it gives a chilling effect that a city would elevate its own interests, especially over identical remedies, over an owner's ability to provide a practical solution that solves the problem.
You have Gordy.
As a former lake owner myself, I know what George is going through. George Kinsler and I have been friends for many years. He's a great Monona guy, very smart, and he gave me the shirt off his back. I'm here tonight to ask you to grant Mr. Kinsler's request to do all full remodeling as existing without any setbacks whatsoever. I hope you will vote in his favor. You won't be sorry. Thank you.
And then we have Mike Feldman.
Yeah, hey, Mike Buzzard. Lifelong property owner in Monona, ex-alderman. I've been through a number of these cases over the years, and I look at this in a couple of different ways. I did write y'all a letter. I could read it again, but I'll just say this. After hearing everything that I just heard, why this has been litigated is, I don't know why this offer wasn't on the table right from the day one. Kinslers, please tear down your house and rebuild it on the same site, or done. And I just don't understand why this is not an acceptable proposal, other than if their plans are outside that footprint, well, then amend the plans. I literally have seen thousands of dollars as an alderman, as a citizen, wasted. And that's the way I'm looking at this, and I still own property in Monona, even though I don't live here. Thanks, guys.
Anybody else here to speak?
I'm Mike Kane, I live on
Mike Kane.
49 Kane. I submitted a letter to support George. I've gone through these problems also. I live on the lake. I bought the property next door to my property from the founder of Apple. We divided it in half. I have a city public walkway easement on my property. I pay taxes for. There's sewer lines, there's sanitary sewer lines that go through my property that restrict where I could build. I built a big addition onto my house. It's like over $1 million, and I went through this process of getting the variance, and I just cannot possibly understand why people that buy property on the lake can't expect that their property should be able to be rebuilt exactly where it sits for the minute they bought it. It was proper when it was built. It should be proper to have it rebuilt today.
Thank you. And seeing no others in the Zoom room for the public hearing, and we've exhausted everybody here, but Doug has his hand raised.
Just a question, does it make sense that what letters that was submitted to me that I have printed out that we do have that we have not heard from? Does it-
Yeah.
Just as a question.
Yeah, typically we've read those in, so do you have those? Do you have them, guys? No.
In that, forward.
Michael Kane. So Michael, is there additional information in here? The same, all right, so we'll skip your letter. Mike, that's all right?
Yeah, I just didn't get into the specifics because I figured you guys had the letter, so I didn't read it, so I'll read it into the record, go ahead.
The staff and board members of the zoning board of appeals, why are you denying a long-term Monona resident philanthropist an advocate the right to rebuild his house under their proposed plan? I find this very disconcerting as a lifelong property owner in Monona. I would ask at least 5 questions, as I have seen this attorney of ours lose more than once. What was your original complaint? Who served the original complaint? What was served to this owner to cure, and what remedy was offered? I served the city in the past as an ex-council person. I would have had a hard time not allowing this couple to add to the marginal value of Monona's coast. This is an overreach if the Kinsler family is committed to rebuilding. Why would we deny this property to be diminished this way? And then we have Danielle, let's see. Daniel Gutman. I regret that I'm unable to attend the upcoming zoning board meeting regarding the property at 4539 Winterville Road. However, I'd like to formally express my opposition to the variance request submitted by George Kinsler of Ramona Roar. For years, this property has been both an eyesore and a safety concern for our neighborhood. I do not support granting a variance that would allow them to rebuild using the existing foundation and footprint. Instead, I strongly believe that they should be held to the same zoning standards as other homes in the areas, ensuring that any new construction adheres to the appropriate setbacks required for lakeside properties.
I believe it's next door neighbor Gutzman. Goetzman. Gutzman. It's branded. It's something different.
Yeah, that was somebody different.
Okay. Thank you.
Oh, yeah, you could be right. It could have been passed on. Because it attaches my letter form. You're right.
So
Brandon,
it could be right or I am right.
I believe you're right.
Okay.
Brandon Grutzman.
That's how he spells his name.
Yeah,
You got a match?
yeah,
Okay, thank you.
and then. Well, here's their attached letters. So were there two, Doug?
Yes.
So there's this, that's from Daniel.
Correct. That's,
And then there's this. And that's from this. Okay,
that was
there
incorporating
are two different individuals. One was Daniel.
Okay, I just,
And then there's a letter, the next one is Brandon and Emily.
Yep.
You guys are gonna test. All right, so we are unable to attend the zoning board meeting in person due to travel conflicts. Thus, we're writing to express our strong opposition to the variance request submitted by George and Ramona regarding the property at 4539 Liverpool Road. As an adjacent neighbor to the property, we're deeply concerned about the ongoing condition of the property, the negative impact on the surrounding neighborhood. The structure at 4539 Liverpool Road has long been in a state of nuisance repair, creating both an eyesore and potential safety hazard. Given the existing court order to harass the property, we believe it is imperative that the city enforce this order without delay, allowing applicants to circumvent this directive by attempting to rebuild on the same foundation will only prolong the current issue and set a concerning precedent for other non-conforming properties in Monona. Maintaining the existing foundation in Chimney should not be a sufficient grounds to circumvent Monona Ordinance 484/40A, because pursuant to the homeowner's plans as proposed would result in material structural alteration and subsequent reconstruction of the house in a non-conforming footprint, which is not allowed for lawful non-conforming structures under the ordinance. The deteriorating condition of the home has already been affecting the neighborhood property values and overall appearance of the community. The structure has been deemed beyond reasonable repair, and further delay in its removal is unfair to those who take pride in maintaining our homes. Full demolition as previously ordered is the only reasonable solution. Urge the board to reject this variance request and uphold the city's prior decisions regarding this property. The integrity of Monona's zoning laws and the well-being of our neighborhood depend on fair and consistent enforcement of regulations. That was Brandon. Susan and Peter Turney. They haven't been here, so we received a letter from Doug Plowman regarding the Director of Planning and Economic Development from Monona. Because we own property close to George and Ramona, we were notified of the public hearing scheduled for tonight. We are not able to attend in person or by Zoom, therefore we want to submit this comment by email. We have improved our property and are pleased to hear that they too want to improve their property. Improving this property would be a benefit to our community. We would ask the zoning board to approve this request as long as the project meets code. And then Michael Fritz, I now actually do have your letter, but you read it so much better than I could, so thank you, sir. And those were all the letters. Seeing no other individuals here and no other individuals on the screen.
do we read one from the Griffin Dorson?
Recall one. It's on the recall.
Well, I have a copy. This was also sent to me along with.
Okay. This one must have this.
It was, I did not see that.
Okay, so this one is, I was surprised, gentlemen, I was surprised to see the city reject Mr. Kindler's request to replace his cottage on the same foundation. I believe in the past, the city has allowed such requests. It would appear that the proposed location is appropriate as regards to the adjacent properties. The proposal would not significantly change things from what exists now. I would support the application. This is from Griffin Dorsch.
Former planning commission.
Excuse me.
Do I have that copy?
I have a question.
Yes.
I'm also a realtor and I've never heard if people want to remedy an existing plot that they get denied that in other counties, so. In villages, I don't understand why Monona has such a big problem like this.
in the public hearing section, we can't go, like, I can't engage in a dialogue beyond those pieces. I can refer you to like what our ordinance say. I can't go into necessarily discussion of why it exists the way it exists.
Just from a realtor standpoint, if there's an existing wall there, they're able to build and run into it. So,
Yep, and I believe we'll be getting into elements of that in the next section.
okay.
So, all right.
I've gotten a comment pop up.
Michael, did you have something to add to your comment?
I just wanted to clarify, the people who have sent letters, aside from the attorneys who are not directly neighbors of the Kinslers, are all in opposition of this proposal. And the comments we've seen supporting it are no one who has to live near him, near the Kinslers. We've endured a lot of discomfort and aggravation over the years with trees not being maintained, falling over our property, having to get the city involved to remove them. And we've had blue snow of tarp raining on our property from the tarps on the roof, asphalt shingles blanketing our yard when we have a north wind. If the Kinslers were good faith neighbors to us and maintain their property over the years, we would be in support of it. But they've shown themselves to be bad actors. And that's just, calling a spade here. And as I understand it, this proposal is for expansion and additional encroachment, and it's a clear-cut case.
All right, thank you, Mr. Fritz. And seeing no other people here for the public hearing section, we will close that and move on to item 6, which is consideration of action. And this is pursuant to the city code 175-12A for George Kinsler of Ramona Roar at 4539 Winnebago Road. They are appealing the decision of the city's building inspector dated January 3rd, 2025 and January 13th, 2025. Denying the building permit's request to repair, replace, remediate, replace, and remodel existing improvements. And to remove first and second floor above floor deck and foundation, maintaining a masonry fireplace. And this is case Z1 of 2025.
I was wondering if I might have just a brief moment to respond to a few things that have been said.
You can add that as part of your presentation if you'd like.
Is that now or?
That would be now.
Okay.
Now, it's not going to be a back and forth with people.
Sure, understood, understood.
But if it's part of your presentation as the party coming forward for consideration.
Right.
By all means.
Yeah, sure. So I would just wanted to, as we consider this further, I think there were some important things to clear up. Because I heard a lot of statements that are not really germane to what we are here to talk about. First of all, there was a comment from Mr. Fritz about the rules pertaining to legal non-conforming.
Hang on for one piece. During a public hearing, I'm just going to clarify so you don't go down my trail that you don't need to. In a public hearing statement, I allow people some great latitude if they want to talk about things that aren't directly relevant to the decision that this body has to make tonight.
Right.
But they feel it's part of their story. I'm going to let them share that, right? This body knows that their decision tonight is specific to the two requests that were denied and why they were denied. And to hear the case presented that you're bringing forward and to hear the evidence from the city side and make a determination. Are we upholding the decision of the building inspector? Why or why not? And if we're denying it, what they did, why or why not? So,
sure.
Yeah.
I
Don't feel like you have to go down to chase bunny trails that
I'm gonna try not
are
to go
not
down
those items.
Right, I'm not gonna try not to go down too many.
Yeah, sorry,
Thanks.
before you kind of get into it, I guess just from a clarification standpoint, from a procedural standpoint, which actually this might be better directed to the attorney that's representing the board. Obviously, the board has the authority to conduct like a de novo review. It has the authority to conduct just kind of a record review. Are we going to be, is the board going to be taking evidence or just reviewing the record and hearing argument from the attorneys?
We're willing to take whatever you have. If either of you wants to present evidence, we'll take evidence. If you want to just argue, you can. So I was under the impression you were going to be presenting evidence, and that's perfectly fine.
Yeah, well, I mean, I think there might be a few things. I think most of what the board needs to know is in the packet. We'll be adding a few additional things for some context, but I believe what the board has to consider is largely present in the packet. And so but I was getting back, I wanted to clarify though, we are not talking about, again, changing a use here. Well, this is residentially zoned. We are going to continue that zone. So there's been no discontinuation of a legal non-conforming use. We're going to put it to residential use. And again, I want to clarify, and this is also not a variance. This is, we're asking you, not to give any special exception. Our position here is that what we have requested is legal. If we're going to hear from Mr. Kinsler, it has always been my understanding that what has been proposed in the building permit is to build effectively in the same in the same footprint. I imagine we are going to hear from exactly how that exceeds that, but I just want to make clear here too that when we say the same footprint, technically what the ordinance only requires is that there be no additional encroachment on zoning regulations. And so to my understanding, the only violation here is the lakeside setback. So I don't know if there's any other expansions elsewhere, but the ordinance only requires that you not further encroach on zoning regulations. It does not, strictly speaking, require building in the same exact footprint. And also, to the extent there might be in the application any slight additional encroachments, this, by statute, this body has the power to make any decision or determination as ought to be made. And to that end shall have all the powers of the officer from whom the appeal is taken and may issue or direct the issue of a permit. And so what we are looking here for is the ability to reconstruct a residence in conformity with section 480-40A, allowing it with the same lakeside setbacks. And if there needs to be some minor adjustments to the building application, we are willing to do that. That's not under our understanding of what the designs call for. So with that, I guess I ask Mr. Kinsler.
I have one question.
So we're beyond the public comment section. So unfortunately.
So do I have to come up there? I can just sit here.
If everyone.
Up to you.
Anybody besides the attorney, I should be swearing in. Okay. I'm gonna swear you in. So all you gotta do is affirm this, all right? Solemnly swear or affirm that the testimony that you're about to give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Kinsler, you've seen the record so far in this case, the board packet that was submitted to this. Yeah, okay. And that packet contained the building permits that you filed on the subject of this hearing? It did. The design and placement of the structure, what is your understanding of how that structure is designed with respect to the existing dimensions of your?
The intention was to make use of the current foundation and maintain the tunnel for my accessibility and to keep the fireplace. Because we'd have a fireplace then in our new building rather than have to tear it down. So the intention and the whole idea of how the draftsperson was charged, if you will, was to overlay on the existing footprint and foundation footings.
Okay. And if there is anything about the design as submitted that is not consistent with that, you are.
Certainly willing to amend it if that's an error by the draftsperson, it can be fixed.
Okay. Could you explain why you feel it's important to be able to build on the same footprint?
Can we hand these out? I think we have enough. If not, I've got extras. Pass them around the room and I've got some more to draw on there. You know how many you need for Mr. Plowman?
Whatever I get, I'll hand in for minutes.
So you got two pieces of paper and a survey drawing on top. When you run out, tell me, you know.
I'm gonna give him my packet rundown.
Oh, here, I've got it.
Fine. No, that's difference. As much as you want to call it. Okay.
So you handed, submitted two sheets of paper on either side.
You want me to describe what you're looking at?
Should we start with the pictures?
No, let's start with the survey drawing.
Oh, survey. Okay.
So Williamson survey went out to the property. And amended what you can see there. January 10th. Williamson survey went out and what they did was they took the survey that they had done earlier. And marked where 50-foot setback would be, which we highlighted in orange for you. So you can see that the impact physically across the existing location. Which I think you'd agree was substantial. If you flip it over on the side behind it, what you're looking at is the side yard and Mr. Fritz's house. And what you're seeing there is where the front of a new structure, per what it's been told to us by the building inspector, that would be the front.
Front meaning facing lake.
Facing the lake, it would be. If you go to the next picture behind it, I had the surveyor, when they marked the 50-foot setback or the additional 25 feet, put right on the building across from the stake, so you would see how much the property itself was impacted. I'm not sure what that serves by setting it back that far, other than Mr. Fritz getting his opportunity to get a pound of flesh and punish us or penalize us. And I've read the statute as long as everyone else is practicing law. The statute with the raise doesn't have a penalty. It doesn't have a punishment like a statutory thing would do. I don't have to go to prison. Okay, what we have to do is make society, the community safe. We're willing to do that. Would you like history or not?
I think yes.
You asked me in case they wanted to know the history of this. I could sure do that if you'd like. If not, that's okay. I don't need to.
No, yeah, we just wanted to make sure everyone understood for the record why it was important to you that he builds on the same location. There were some other photographs that you shared with me. I hand that out. Can you tell me what those pictures are?
Certainly.
But hold on until I get them to everybody. Hands. Tell us what the pictures we just handed out are.
Sure. The first set that you saw is where the property would have to be moved back to, or new construction would have as a face to the front. And you can see the vistas of Lake Monona, both east and west. What Attorney Fleming has just handed to you is on one side, it says current view to west. Okay, so that would be towards the Getzmans. So that picture was taken right at the front of the existing porch where the front of the reconstructed home would be. So you can see a substantial difference in the vista and the Madison skyline at that location. So if you take a look at the picture, the second picture that I initially gave you, which is the stake next to the air conditioner. Not that one, that here's the one in your right hand is that, there you go. Now you have it together. Okay, so there's your difference in vista and what you see. And you can understand why we spent three years trying to protect where our house could be. And if you look on the backside picture, that Attorney Fleming just handed to you, that's what we see now, looking across Mr. Fritz's back patio area and through his dying maple tree. So, I mean, we think it's pretty substantial. This is a classic, a picture's worth 1,000 words. I think it gives you insight, perspective. Did you want me to explain about the permit or not?
The permit's what we're here to talk about, right?
The COVID permit.
Oh, the initial, sure, I mean, it's been brought up that the property has been this way for a while. I think that's, the board might like to hear.
You may want to know how did we get here? I mean, if I was, as you saw in my resume on the back, I was on ZBA, so I've sat in your chair, maybe not the same time, but same.
Hopefully they're here.
We made a permit application to the city of Monona on March 5th, 2020. Now, I don't know what you remember about 2020, but in our case, not much was good. Because right after we made the application, and we paid our $484, which is in the city's records, you can go and find it. Kimball sent us out our building permit, and then COVID shut everything down. And that impacted our plans for what we wanted to do. Because it not only dramatically impacted the world, but it also impacted our financial world personally, and also the contractors we could get who could work, and also the business that we have that tutors children on site. So we literally had to shut our business down. So our plans to build were stymied. And like I said, I think we all remember what COVID was like.
So that permit was for a
Reconstruction,
reconstruction at the time.
and it was approved.
Okay, why is that not in tonight's package? If you're saying you submitted plans to do what you're wanting to do, and it was approved at one time, why aren't you presenting that?
Thank you for answering that question.
Because like,
On June 27th, 2022. After receiving the raise order.
but hang
No,
on,
no, I'm answering your question.
okay, because I should have a piece of paper in my hand from March 2020 that says we applied and I got approval. Where is that?
Thanks for asking. So after we got the raise order out of the blue, we came out here and made an open records request. That was on June 27th of 22, and I gave them a cash deposit of $500, of which I brought the receipt here, and I could show it to you, that it was for an open records request. When that response was finally responded to, we're told by the city of Monona that we needed to pay them $7,500 for an open records request. As of this time, none of our open records requests have been filled. So I can't give you the permit that you have in the filing cabinet next door.
But weren't you given that permit in 2020?
We put it up on the building. And I didn't make a copy of it. I don't have a copy of it, but you do.
But that permit would have expired. A building permit is typically only good for 2 years, so. I mean, your point's well taken. We did not introduce it other than the testimony here about the history because that building permit expired and that's not the application we're appealing. It was actually granted at the time, but ended up
Sure, it would be
expiring.
nice for you guys to tell us if it's the same as this.
George, do you know what the degree to which there's any variance between your prior permit and permit application and this one?
Bear with me. I can give you all the pieces. That's the letter to Lee. It's a copy of the check. It's a copy of the plan where we kept the existing basement. And those are notices from Mr. Bortz, who works for this fellow. Acknowledging that there was a permit out there because he wanted to do inspections. And those are the emails.
Do you have your email that shows your public records request?
Keep going. Where's your receipt? See the last page?
That's just a receipt, but it doesn't indicate what your public records request was.
I do not have that here, and that's with other counsel. Previous counsel, I guess is what I.
So if you want to answer those, you know, it's up to you.
Yeah, those was discussed.
Yeah, sure.
Any questions that you have of me based on what I said for clarity I mean, really wanted to bring in the picture series. This is what I dug my heels in on 3 years ago when I was surprised that with no letter, no email, no citation, no fine, a raise order. When the city went into the property, they had to come to municipal court to give permission. No notice, no hearing, no request, no show up. They just got it. So I don't have any of that documentation because I never got anything. So here I sit, wasting the city's time and spending the city's money and mine 3 years later. Because all I want to do is build a house in the same location.
You want to take a look? For the. I think that is. That's case for right now. That is our case for now.
Do you have any questions for Mr. Kinsler?
How long, when was the last time you resided in the property?
It's ongoing. As a matter of fact, I can show you documentation according to the DNR. City of Monona. You would like those copies. I have them. I get mail there all the time. I'm registered to vote out of there. I don't have ownership to another homestead. That's my homestead, okay? I vote out of there. Our ski boat's there, our pontoon boat's there, we fish there, we picnic there, so we use that property. Worst case is a second home. So it qualifies as a second home, just like a congressperson or a senator in Washington. So that's my answer. It's my house.
So my question, sir, is when was the last time you resided there?
Stayed there. I can't remember when I've stayed there. I mean, do I have to sleep overnight to reside there, or is it my use?
So I can re-ask the question. When was the last time you slept overnight in the house?
I can't recall.
Was it within the last 5 years?
May have been.
Was it within the last 10 years?
I can't tell you if it is or wouldn't, but it would seem certainly within the last 10 years, but I use it. It's my house. I use it.
Okay.
Okay? So I have not abandoned that property, if that's what your point is.
I'm not, sir. I'm just asking some
Oh,
questions.
okay.
And you're aware that the raise order was issued back in April of 2022?
Sure, I was in court with you.
And at the circuit court, one of some of the arguments that you made to try and get the raise order essentially deemed invalid or unreasonable was that you told the court you wanted to rebuild on the same foundation.
Yeah.
Okay, and you talked to the court about kind of the setback issue and the view changes from your property.
Setback, I don't understand your question.
Certainly, we looked at some pictures. Actually, I don't know that we marked it as an exhibit, but this picture here that says subject property on both sides. You talked at or your witnesses at the circuit court talked about how the view from your property would change if you had to move the house on the property back.
You're saying I said that or my witnesses did?
Your witnesses.
According to the transcripts, they did.
Okay. And ultimately, the circuit court upheld the raise order.
As did the appellate. And you misspoke when you said the Supreme Court denied us. They denied hearing the case.
Correct, they denied the petition.
You didn't say that. You said when you entered here that they denied it. They denied the petition. They never looked at it.
Okay. So my question though is the circuit court rejected your request to deem the raise order unreasonable and the circuit court upheld the raise order?
They wanted us to remedy or cure the defective property.
Sir, that wasn't my question. My question
Well,
was
I
pertaining
answered
to
your
the raise
question.
order.
They wanted, Judge Slipper wanted the defective property cured.
Okay.
She wanted it gone.
Is it fair to say though, we're still here talking about the property. It's fair to say you have not raised the property on Winnequa Road?
Is it fair to say I was told I couldn't do anything?
Could I just get a yes or no? Did you raise the property or not?
I don't think I have to answer that question. It's clear.
It's clear you have not
Unless
raised.
council wants to direct me to.
I think we will stipulate that the structure's
The
still there.
structure's there.
I think
So it hasn't been around.
we're, one of the things we're appealing is a denial of a demolition permit.
Because we've been trying to do that.
We were told we couldn't demolish it.
Okay. And you were given an opportunity prior to going to court to raise the property and demolish the building.
Would you explain that to me, how that was done?
Can I get some guidance here on whether or not the witness is gonna answer the questions here? I don't know that.
You were saying something, But you alluded to something, and I'd like you to share with the people what it is that you are alluding to.
Talking to me or Mr.
I'm
Fleming?
talking to you.
Um,
Your question is, was I given time?
my question is, you were given 30 days pursuant to the raise order to raise the building, correct?
That's accurate.
Okay, those are all the questions I have for you.
Do you have any other individuals that you? Anything else that you want to add?
Well, I mean, I would say this, I think what this line of questioning is over, is there was a case where the reasonableness of the raise order was challenged. Now, this may seem a very similar case, but it is different procedurally. Here, the court was not looking at a proposal for a specific building permit for a specific plan to go ahead and do something. There was a challenge by Mr. Kinsler with prior counsel to challenge the reasonableness of the raise order. The court found that the raise order was reasonable. We're not challenging whether the structure that the raise order was issued on does need to come down. That issue is now off the table because that's what is litigated. What is here today is not the reasonableness of the raise order broadly. What is here today before you is whether we can build a new structure on top of the existing foundation. That is the issue we're here about today. Now, could this discussion have happened maybe some other time? I don't know. I was not present in these things, but this is a different posture. And that's what we're asking the board to consider here today.
All right.
Mr. Fleming, one of the things you're appealing is the denial of a demolition permit.
Right.
And a demolition permit was for partial demolition or the partial raising of the property.
Correct.
The city has an order from the court that says they can do a total raising of the property.
Correct.
Aren't you essentially asking this board to overrule the Court of Appeals on that issue? I mean, how is that different?
Well, it's different because, here, this is part of a entire application. We're not just challenging the reasonableness of the raise order. We are asking for approval to go forward to do something that is allowed by the zoning code. Now, when a raise order is issued, there's specific procedures you have to follow. You can only go to the circuit court and challenge the reasonableness of the raise order. Here, we are considering the application to do a partial raise, getting rid of most of the building, all the parts of the building that are in disrepair, and reconstruct on the same footprint. That is appealable to this body, and this body has the same exact power that the building inspector does. The court in a raise order case does not have that same power. The court is limited to considering whether the raise is reasonable or not reasonable. And I think there's little question that the building inspector could have approved this demolition permit that we're appealing and could have approved our building permit. Those were powers that this building inspector had. The court's order did not say that the building inspector absolutely has to raise the order. It could have done something different.
I understand, but the city still has a raise order. So if you do your partial raise, can the city then come in and do the rest of it?
Well, I would hope that that would not be the result. I mean, this would overturn the building inspector's determination that the entire thing has to be raised, that because that would be contrary to this application. So if this application is granted, I can see that it would affect the scope of the raise order. But again, this is because the building inspector still retains that authority. He could say, yeah, this serves the public interest. This does, in fact, get rid of the dangerous, dilapidated, unfit for human habitation structure and replaces it with a new one.
But you would agree that it doesn't change the raise.
Well, I think it changes the building inspector's determination of the scope of the raise order, yes, because that's the basis, part of the basis of the denial of the permit, although the building inspector phrased the denial in terms of, at least it appeared to me, as if the building inspector believed that the court's order meant that the raise order as if he had no power. And so that's really the error that we're pointing out technically, is that the building inspector does have the power. And the building inspector chose not to exercise that power to allow the more limited raise and grant the building permit. But this body has those same powers, and that's the powers we're asking.
I'm not questioning whether they have the power to approve permits. I agree with you. I'm just trying, if it's an unusual case where people are arguing over who gets to raise property, it seems to me.
Yeah. It is different. Like I said, if had I been involved many years ago, I don't know if we would have followed the same trajectory. Maybe we still would have been up here. But this is the situation we are faced with today. We're asking to do something that is legal. And all we're asking is for this board to allow us to do something that is legal.
Do you have any other witnesses or any other?
No.
testimony you want to present?
No.
Ms. Tierney?
So we're gonna call a couple of witnesses and go through some documentation entered into the record. The first witness is gonna be Doug Plowman.
Doug, you ready? Do you solemnly swear or affirm that the testimony that you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
All right, Doug, can you just remind everybody where you're employed
I'm employed for the city of Monona.
and what do you do for the city of Monona?
I'm the director of planning and economic development.
What do your duties involve as the director of planning and community development?
A couple different things, but most fundamental for this is I am the zoning administrator. I oversee the planning policy.
So are you familiar as the zoning administrator with the zoning code and regulations for Monona? Okay. Do you apply and interpret zoning codes and regulations as part of your job?
Yes.
Okay. Are you familiar with the property located at 4539 Winnequa Road? Is that in Monona? How are you familiar with it?
This has come across since my time with the city, just about 6 years ago. I've been copied on emails about code enforcement and sort of property concerns, but also, of course, the building permits that have come.
Okay. Tell me a little bit about, so you said you started with Monona almost 6 years ago?
Yes.
Tell me about some of the complaints that you have received predating 2020 with the property.
So predating 2020, there were property complaints, I believe from nearby neighbors. Again, I was copied on these. The way these are sent through the city is that depending on the contact form, it will go to the appropriate staff members. So I was one of those included on it. And there were concerns about the property maintenance, I believe general property health.
Do you have any more recollection about the specifics of the complaints, like what it was about the property?
It was the upkeep, certainly. There were concerns just about the maintenance generally. I don't have any specific.
Okay. Are you aware of the zoning regulations that are applicable to this specific property?
Yes.
All right. Is the property currently in conformity with zoning regulations?
It is not.
We've heard some discussion about it being a legal non-conforming use. What does that mean?
So what that means is that the property predates the current zoning that is in place and is allowed to be to remain in place as it is. But effectively that it would not be able to be built today in its current setting.
Okay, and there was a survey that was sometimes the charm. We've got a copy of that survey.
Yes.
The middle there's, it's like 5 structures on the survey. It's the middle structure that we're talking about here.
Yes.
And so there's an orange line going through. Can you explain what that orange line means in relation to the zoning regulations?
Yes, my understanding, again, it's not overly clear here, but the lake properties, lakefront properties are subject to the meander line setback, which is the shore yard setback. So there are different yards for the property, when looking at zoning. Street yard, any part of the property that faces the street, side yard would abut adjacent properties, and then of course, shore yard would be any body of water. So in this instance, we see Lake Monona at the top of the page. So that section of the yard, that section of the property would be deemed to be the shore yard. I believe, I don't necessarily see a marking on here, but that dotted line that says 49.60, that line sort of running 45 degrees through the property, that I would interpret that to be the meander line. So the meander line is important for the shore yard, and that is the area that the setback is taken from for the shore yard. So 50-foot, the yellow line, it appears there's a 50-foot line drawn from that meander line to the south, which would be effectively the closest that a new structure could be built.
Okay. And you said there are also setbacks from the street yard and the side yards?
That's correct, yes.
Okay, and do you know, based on your understanding of where the house sits on the property and those zoning regulations, if the house currently is in conformity with the setbacks for the side yard?
With this survey, it's hard to tell, but based off of the location, the width of the lot, 49.60, it appears that the western, the left side of this would be close, very close to that side yard, which is a 7-foot side yard setback, as shown in the existing form.
Okay, I want to go through a little bit of the history of the property here. You've got a binder in front of you. If you could turn to Exhibit 2. Can you identify what Exhibit 2 is?
Yes, this is a order to raise the building is 4539.
Okay, and on the second page, this is signed by the City of Monona Building Inspector.
Yes.
Okay, and the second page has the orders ordering the owners of the property to raise the building on the property. Okay. And obviously the property has not been raised.
That's correct.
Okay. Are you aware of whether the applicant challenged this raise order?
They did, yes.
Okay. You were not present at that court hearing?
That's correct. I was not.
Are you aware of the outcome of that court hearing?
The hearing was upheld.
Okay. And have you seen a copy of that decision?
Yes.
Okay, I'm gonna have you turn to tab 4. Is that the court order affirming or upholding the reasonableness of the prior raise order that we looked at?
It is, yes.
And pursuant to this, Monona may enter upon the property to raise the building as defined in the statute cited there. Did the city have an opportunity to proceed with the raise after this raise order was upheld in September of 2022?
No, they did not. There was a stay that was ordered.
Okay, before the stay was ordered, did the applicants here file an appeal?
I believe they did.
Okay, I'll turn to tab 6. You've seen a copy of their notice of appeal,
Yes.
and that's appealing it to the Court of Appeals.
Yes.
Okay, and then you made reference there was a stay or a pause put into effect. All right, and we'll take a look at tab 6. That is the order granting petitioner's motion to stay pending appeal. So effectively, could the city act on the raise order with this stay in place?
They could not.
It took a while for a decision to come down from the Court of Appeals, right?
It did, yes.
Taking a look, and you can reference if you need tab 7, when was the decision issued from the Court of Appeals?
I believe it was over a year after the appeal was made.
Okay, and the date of the decision in tab 7, that's May 31st, 2024. You're on 6. There you go.
May 31st, 2024, yes. That's
Okay.
correct.
And just for reference, the original raise order was April of 22.
Yes.
So after this decision came out, did the city get to go in and raise the property?
No,
Okay, the stay remained in effect.
yes,
All right, so we'll take a look at tab 8. Have you seen this decision in order?
yes,
All right, and this decision in order kept the stay in place until such time as the applicants and petitioners, to the extent they wanted to petition the Wisconsin Supreme Court.
yes.
Do you know if they did petition the Wisconsin Supreme Court to hear their race case?
They did.
And do you know what the outcome of that petition was?
I believe that it was not taken up by the Supreme Court.
Okay, and that's reflected in Exhibit 9.
Yes, it is.
All right. So the petition for review was denied by the Wisconsin Supreme Court on December 10th of 2024, and the stay was then lifted. Since the stay was lifted in mid-December of 2024, was the city able to proceed then with the raise order?
Yes, the city has begun steps towards the raised order. Most notably that the RFP, the request for proposals for that demolition, went out.
Okay, and did the city receive bids?
Yes, the city received bids, and I believe the RFP went out, it was dated February 14th, 2025, and 4 bids were received.
Okay. Now we're here today specifically to review the denial of 2 permit applications. Have you seen the first permit application dated December 16th of 2024?
Yes,
All right, and that's in tab 10. And there were some drawings submitted with this application. That's in tab 11. Okay. Now, at the time this application was received, December 16th, this was after the stay was lifted and the raise order was back in effect.
yes.
Okay. Based on your review of, you can look at, again, it's kind of a 2-part. It's tab 10 is the kind of paper submission and tab 11 is a print of the drawings. Does the proposed construction demonstrate whether the construction would result in additional encroachments on zoning regulations?
It does not clearly state that. It does not show one way or the other. So the expectation in this instance, in order to review against the non-conforming, would be to really outline clearly new versus existing and to look at those elements. Staff specifically have concerns about the additions on either side of the building, which would be to the east and the west.
Can you, before you get going, can you tell us what additions you're looking at in relation to Exhibit 11?
Exhibit 11 specifically on the page that is marked page number 1 of the draft person. There are sort of 4 elevations here of the property. On the right side, there are 2 decks or sort of landing areas that appear to be shown.
Sorry, so real quick, I'm
Yeah.
kind of flipping around. It's the 3rd page of the exhibit,
Oh, thank you.
but it's marked page 1. Okay, go ahead.
Specifically those areas, they are attached to the house, they are part of the primary structure, we can subject to those setbacks and those standards. There are other elements that are included. There are portions of this plan that specifies new, some of these drawings that include new. There is also, on the same page, not to be jumping around, but the same page, top left, there's a note that says the grade will be raised to some extent and does not specify it accounts for the slope effectively on the property. That is another feature of chapter 480 of the zoning code that I would be looking at to see the proposed changes. There are standards about the amount of grading that can take place for a special exception.
Okay, so grading changes to the property would fall under chapter 480.
Correct.
And do you have enough information on this application to determine that there will not be any grade changes?
I do.
Okay, and the 2 structures to the east and, or the structural changes to the east and west that you're referring to, those are on this 3rd page again. Right-hand side, we're looking at, looks like kind of a deck on either side and a rail And those are new additions to the property?
That is my understanding, yes.
All right, now we talked a little bit about the side yard setback. And you said it was a 7-foot setback?
Yes.
Would either of those additions to the east and west encroach upon that setback?
My understanding is that to the left of the house, the west would encroach, just given referencing the survey that has been shared, and just the general location of the property. It's not evenly distributed or evenly located within that. It appears that the property is closer to the western property line. And subsequently, there's concern about the improvements there.
All right, and one of the photos that the applicant submitted, we can see the chimney in the fireplace. And it looks like one of the additions is right by that chimney, so we can see how close the chimney already is to the side yard, to the boundary line. On the drawing, is there an indication of how big that additional encroachment might be?
I would reference the previous page in tab 11. And it has 2 field lines. And this shows at the bottom on the left side, dimensions. I think it's 6 feet from the house, 4 feet from the chimney. Reading that.
Okay, so we're looking on the bottom here. We've got the chimney, and then it references, that's what you're talking about down here, this addition, the 6 foot and 4 foot?
Correct. Yes.
Okay. Is there additional information that's missing from the application that you would need from a zoning perspective?
Yes, for anything of this type, the expectation would be that we would have a stamped survey from a licensed surveyor. So this information that was presented this evening, this survey, I would expect that, but certainly in greater detail, so I can really make out the distances. But that would be important to ensure that the improvements being made both match the existing footprint. I'll be able to use that to reference that. But I have also seen applications that do seek to rebuild without the additional encroachment. They will often show 1-for-1. So let's say it's a 10 by 10 structure, they will show an existing, they will show the proposed. This, a lot of it is sort of looking through the plans and interpreting. So I would say more information, but absolutely the survey, and with the proposed grading, I have seen with improvements such as this, we have requested a grading plan stamped by whether it's a land surveyor or other professional that would also include that to make sure that it meets the ordinance settings.
There was another general building permit application that Mr. Kinsler submitted on January 11th of 2025. I'll draw your attention to tab 13. Based on your review of this application, does the proposed demolition and removal of first and second floor indicate whether or not there would be additional encroachment on zoning regulations?
It is not clear, yeah.
Is the application missing any information from a zoning perspective?
From a zoning perspective with this, I would expect some form of a site plan to be included. It would include, we would be looking most likely more building, but we typically expect to see an erosion control plan to see the sort of limits of disturbance. And again, you can begin to piece these things together. But this application is listed in tab 13, does not include any drawings or any information for the proposal. And we would simply be going off project description, also interpreting what the policy is.
Okay. Would it be permissible under zoning regulations to have a basement and foundation and fireplace and boathouse, but no principal structure?
The expectation would be that the boathouse would be accessory. It would be an accessory structure to the main building. And so the basement, as proposed, we would expect to see. We recognize there may be sequencing that you may start maybe at the lake and move back, but we would expect to see improvements to the main structure as well.
So somebody could not be in compliance with Monona's zoning ordinances by simply having a basement, a foundation, a fireplace and a boathouse?
It would not appear to be inhabitable, and so there would be concerns about that primary structure.
And that would be actually a new zoning violation.
It would be.
Those are all of the questions I have for Mr. Baumann.
You indicated, well, that there's quite a bit, according to your testimony, that you would like to have seen in these applications to be able to evaluate it from a zoning perspective. Correct?
Yes.
You also indicated specifically with regard to grading plans, that you in the past have requested grading plans for similar permits. Isn't it true that whenever you get permits, applications that maybe need more information so you can evaluate it, are they typically denied, or do you request that additional information?
That process is often actually denied by the building inspector with a note. It's sort of a system that this goes through. It's a way of sending that information and saying it's missing this or it needs something else. So specific terminology, whether it's denied or whether it's pending additional information. But typically, and with the system that we use from general engineering, there is an option to effectively deny it and request that be resubmitted.
Okay, and so the effective request to resubmit though comes with a list of things. You explain to the applicant what was missing from the last application. Correct? Okay. Now, in these denials, was any list given to Mr. Kinsler?
That was not shared. Outside of the letter that was prepared.
Okay, and the letter that was prepared just said it violated section 480-40A, correct?
Right.
Okay.
And also referenced the
And the raise order. Right. And I believe you, I also understood you when talking about whether just a floor deck and fireplace would be consistent with zoning. You mentioned that you typically expect, or you see that there's often sequencing in a construction project, correct?
That can be the case if there are improvements being made or new construction of a boathouse, for example. They are often actually on the same permit, but the sequencing just from narrow lots with staging would make sense to start at the lake and come back.
Okay, because if you're reconstructing a house, there's going to be some period where the house isn't going, there's gonna be no house there until you build it, correct?
As I said, most of the permits will include a holistic approach that will
Okay.
include a detached garage or something of that nature.
No, but when by the time the demolition permit had been applied for, there was already also a building permit that had been applied for, showing the intent to reconstruct a house, correct?
That is correct.
Okay. Questions?
I don't have any redirect for Mr. Plowman, so I would next call Mr. Parrott.
Sir, do you solemnly swear to or affirm that the testimony that you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Could you tell the board who you are?
My name is Mike Parrott. I work for General Engineering Company. Who provides the inspection services, building inspection services for the city of Monona.
And how long have you worked with Monona?
Me personally, probably about 6 years, I would say.
Okay, and you said you served as the building inspector for the city of Monona?
I do. I'm not the day-to-day assigned building inspector. I'm actually currently in the would be considered the director of inspection services for general engineering.
What duties and responsibilities do you have in your capacity as a building inspector for Monona?
My involvement this particular project case, yes, was I provided a on-site inspection and evaluation of the subject property.
Okay, and do you review building applications?
From time to time, yes, I do.
Okay, did you review building applications for the property located at 4539 Winnequa Road?
Yes, I do.
Okay, and when issuing a permit, there's an ordinance in Monona that identifies when you shall issue a permit, right?
Correct.
And you shall issue a permit or approve the application if the proposed building enlargement, alteration, demolition complies with all ordinances of the city and laws and lawful orders of the state, correct?
That's correct.
So if an application does not comply with ordinances of the city or laws or lawful orders of the state, can you approve it?
It would be denied.
So we're talking about the property located at 4539 Winnequa Road. How are you familiar with that property?
Again, I was involved in the inspection of the property.
Do you recall when that was?
I believe it was December of 21.
And did you generate a report after your inspection?
I did.
All right, let's take a look at that report. It's under tab 1 in the binder. Is that a copy of your report? All right, I want to discuss some of your findings. This was, you said, December of 2021.
Correct.
Okay. Was the house occupied at the time?
It was not.
Is anybody living in the property?
I saw the one.
Let's talk about kind of your general findings. Looking on page 2 of your report up at the paginations up at the top left. Kind of walk me through very, very high level, the general observations and general findings.
The house was generally found to be in disrepair, suffering from an extended period of deferred maintenance. It was open, easily accessible. Roof was caving in. Inside the floor, the second floor was also caving in. The outside, again, similar to the inside, been, appeared not to have been maintained for a prolonged period.
All right, so you said this, and it's noted in 2.1.2, active leaking on the roof. The second story shed roof was observed to have large holes and to be partially collapsed.
Correct.
All right. Did you observe water infiltration coming through the collapsed roof?
Yes, extensive.
All right, you said there were some structural issues and you referenced the second floor. Were you able to observe the whole property while you were there?
I was not. I went to the interior of the house, navigate the first floor, able to get to the second floor, the stairs. And just, there's a small hallway area landing. I was able to take photos from there, in an attempt to try to take photos a little farther down the hallway in the lake side of the floor, began to give way, so was not able to proceed beyond that point.
Okay, and you were doing this inspection pursuant to a special inspection warrant? What were you've got on page 6, your summary and conclusions. Did you determine that the house was safe?
No, it was not.
Was it sanitary?
It was not.
Was it habitable?
No.
You took some photos while you were there?
I did.
All right, so the photos, are they included starting on page 7?
They are.
Can you kind of just walk us through kind of photo by photo, what we're looking at?
Certainly. First photo is a photo from the roadside, which would be south side house. The second photo is near the home. Taking it back towards the road, south. Third photo, the top photo on page 8 is I would be on the west side, taking a photo to the north. Second photo on page 8 is simply a photo of the west side of the home, showing, you know, the roof, siding. 89, I'll leave my back to the lake, taking a picture of the home. Again, lower photo, similar vantage point. Up page 10, the east side of the home. Taking a picture from lakeside towards the road. Next photo is, I would be on the south east corner of the home, taking a picture.
On the bottom photo.
Yes,
Something blue in the corner of the photo by the house, do you know what that is?
up here.
Yep, right up here.
Yeah, it's a tarp.
Tarp, do you know what the tarp was covering?
The tarp was or had been covering, you know, the holes in the road.
Do you recall how big the hole, were you able to see the holes from the inside?
Yes, you can see from the first floor, you can see up through the second floor, through the ceiling, through the roof to skylight. Daylight.
All right, 11. Let's skip ahead, looking at page 13, is that depicting the second floor kind of caving through?
It is the ceiling, floor structure.
Also seeing the second floor cave through on page 15 in the photos.
Correct.
On page 16, you look to be looking down a flight of stairs. Is this you on the second floor, or are you looking down into the basement there?
I believe that's looking down in the basement.
Okay. Did you do anything or issue any orders after you had conducted your inspection in December of 2021?
Raise order, please.
All right, and exhibit 2, that's a copy of the raise order that you issued.
It is.
And we've been talking about raising the property and demolishing the property. What does it mean to raise a property?
In the strictest sense, raising a property would be demolishing it, tearing it down, and returning the site to dust-free, erosion-free site. All portions of the structure would be removed from basement floor, any plumbing pipes, anything underground, all the way up to the rooftop.
And is raise defined in a statute or a law?
It is
Defined, which is it defined in?
66.0413
The Wisconsin statutes?
Wisconsin state statutes.
Okay. Why did you issue this raise order?
The order was because it was deemed it was unreasonable to repair. It was also found to be dilapidated, old, uninhabitable.
And you said it was deemed unreasonable to repair. What is that based upon?
That's based on a formula. So the cost, I'll read from the raise order. The cost exceeds 50% of the assessed value of the building divided by the ratio of assessed value to the recommended value as last published by the Department of Revenue or the municipality within which the building is located. So City of Monona.
And is that also based on state statute?
It is.
Okay. And the raise order ordered the owners to raise the building within 30 days.
It did.
And the owners did not raise the building.
That's correct.
Were you present for a hearing which occurred on August 30th, 2022, whereby the owners sought to obtain a permanent restraining order to prevent Monona from raising their property pursuant to your raise order?
I was,
And you testified at that hearing,
I did.
and you heard other witnesses talking on behalf of the Kinsler property?
Yeah.
And do you remember what the argument was from the petitioners at that hearing?
Essentially that they would, detract from the review.
Okay, do you remember what they requested at the hearing?
I guess I not fully,
Sure, do you remember if they wanted to knock the building down and rebuild on the same footprint?
that was discussed, yes, it was.
At the conclusion of the hearing, though, the judge issued an oral ruling and she denied their petition for a restraining order, right?
She did.
And the raise order was issued, and we've kind of gone through that already with Mr. Plowman, so we don't have to go through that with you. I do want to talk, though, with you about the two permit applications that bring us here tonight. You received and reviewed a general building permit application from Mr. Kinsler on December 16th, 2024. Is that exhibit 10 in the binder? And drawings were submitted, that's exhibit 11. All right, and at the time this application was submitted, the raise order that Monona, that you had issued, that had a stay on it, the stay had been lifted and the raise order was in effect.
That's correct.
And to this day, the raise order is in effect.
Yes.
Is this application that we're looking at, 10 and 11, is that complete?
It's missing some components,
What components are missing?
contractor information. Also, erosion control, site plan. Such things.
Did you notice any additional zoning encroachments on the plans that were proposed on the December 16th, 2024 application?
Yeah. Based on existing home. Proposed plan. It appears that the two decks, porches, platforms. Means of egress. One on either the east and one on the west side.
And how would those be zoning encroachments?
They would be closer to the side lot, plus they'd be adding the shaped structures.
Could you tell from the plans that were submitted if there were any other expansions of the footprint of the property?
In addition to the new exit to new connector treated deck walkway.
What page are you looking at?
First page in item tab 11.
And you're looking at there in the,
The drawing number 1.
right, and that's the middle draw, there's 3 drawings on that
Yeah,
page.
middle drawing.
And you said there's a new, okay, so new exit to connect to catwalk, new connection, treated deck and walkway.
Yes.
Okay, and that's not existing?
Yeah.
Okay. I know we're looking at kind of building plans, but did the application that is noted in tab 10 actually indicate that this was a rebuild?
No, it just says repair, replace, remediate, replace, and remodel existing improvement.
Did the application that was submitted on December 16, 2024 demonstrate that the proposed building would comply with all ordinances of the city of Monona and all laws and lawful orders of the state?
Did not.
What ordinances did it not comply with?
480. And 40.
And why did it not comply with that?
For the reasons that the diploma. Yes,
Okay, and did the application demonstrate that the proposed building would comply with all lawful orders of the state?
it did not. The raise was still in fact.
Okay, did you issue a written determination?
The letter,
All right, and is that the letter behind tab 12?
yes,
Okay, that was issued on January 3rd. All right, and it indicated that it was denied pursuant to 480-40 sub A and because the property was subject to the raise order.
correct.
Okay. You received and reviewed another general building permit application for Mr. Kinsler on January 11th, 2025, correct?
Yes,
Is that the document behind tab 13?
Yeah.
Okay. And is this application complete?
it is,
What information are you missing?
there was no additional documents submitted with this, no plans. There's also no contractor information at all.
And at the time this application was in effect, the raise order was in effect. If just the first and second floor were removed, would the property be in compliance with zoning? Zoning ordinances?
Could you repeat that?
Sure, so would the property 4539 Winnequa Road, would it be in compliance with applicable zoning codes if what remained there was there, and then they just removed the first and second floor of the main building?
No,
Did the application demonstrate that the proposed partial demolition would comply with all laws and lawful orders of the state? What did it not comply with?
the raise order was in effect.
All right, and did you issue a written determination of this application?
Yes,
And is that what you issued on tab 14?
Yeah.
Okay. And can you just read in the second paragraph there?
the property is subject to a court order dated September 7th, 2022, whereby the property is to be raised. The city is proceeding under the order to raise property. Your application does not seek to raise the property as defined by Wisconsin law. It merely seeks to remove certain portions of the building. Further, your time to raise the property has lapsed. Therefore, the application is denied because it does not comport with the September 7th, 2022 order, Seminole Ordinance 175-8 of E.
One more quick question for you. When you went to go visit the property to do the inspection before the raise order was issued, was the property secure?
Yep.
So you could just walk into it?
Yep.
Okay. I don't have any other questions for you. Thank you.
Well, Mr. Parrott. You denied the building permit because it was a reconstruction of what, of a legal non-conforming use. That's basically what your letter says, correct?
Can you repeat that?
Your letter essentially told Mr. Kinsler when he denied his building permit
Yep.
that he was unlawfully seeking to reconstruct a legal non-conforming structure. And your reading of the ordinance was that you're not allowed to reconstruct a legal non-conforming structure, correct?
Based on the ordinance, yes.
Okay. Your testimony here today, though, is that the plans seem to you to show that there was side yard setback violations.
Sure.
But you didn't deny the permit because it violated those provisions.
That was all part of it, yes.
Where is that in your denial letter?
It mentions the
I think he's looking at the January 3rd.
Yeah, I'm sorry, yeah, okay, I think
Tab 12.
tab 12.
But it does mention the ordinance 480-40.
Correct, and that's dealing with a legal non-conforming structure, right?
I guess maybe I'm not fully understanding your question.
Well, what I'm suggesting here is that, when I read this letter, I hear you telling me that it's a legal non-conforming structure and you can't reconstruct it or enlarge it at all. That's what your letter seems to be stating, correct?
Yes.
Okay,
I would agree with
but
that.
that's not what the ordinance says, is it?
That was at least the interpretation.
Well, you can reconstruct a legal non-conforming structure if there's no additional encroachment on zoning regulations, correct?
That's what it says here.
Okay. And in fact, under that language, it seems you could also enlarge a building as long as there was not a further encroachment on zoning regulations, correct?
I guess yeah, I'm not trying to be evasive.
Sure, no, I understand, yeah. So for instance, to illustrate that point, let's say the application, instead of having the stairs and additional deck on the side, let's just say that it was in the same place with respect to the lake, the meander setbacks.
Sure.
Same place with regard to the side yards, but was a little bit longer, a little closer to the street, but within setbacks. Under 48 or 480-40A, that would be in conformity with the zoning code, correct?
If it meets the setback requirements, I would say yes.
Okay. But you didn't tell Mr. Kinsler that he was violating side yard setbacks with his application, did you?
Not specifically, no.
Okay. And there's nothing in your letter that would have informed him that, okay, well, if I want to have a valid application, I need to go fix that and resubmit it without the side things or whatever, correct?
No, it just says what it says right here.
Now, all the pictures that you had taken back on December 21, were you aware at the time you inspected this that the property had been issued a building permit to?
I was not.
Okay. If in fact, Mr. Kinsler were granted a permit to demolish or largely demolish the existing structure and rebuild on the foundation, none of this that you've taken a picture of, other than to the extent you can see the foundation and fireplace, would exist, would it?
Correct.
Right. I don't have other questions.
I don't have any redirect form. And we don't have any other than, maybe the binder part of the record. We don't have any other witnesses or testimony to present.
Any other board have questions for any of the witnesses?
I do have a question. When a denial letter goes out to an applicant, what is the routine if someone has a question regarding the denial letter?
They can certainly request reason why.
Did the applicant do that?
Not that I'm aware of. Not to me directly.
So I know I was referenced in these letters as being the contact person with any additional questions, and I can say I did not receive any contact from the applicant.
Mr. Calvin?
I didn't know.
Did you contact the city to ask for clarification regarding the denial?
I did not.
Between the first denial letter and the second denial letter, no letter or no questions were asked about why it's being denied of anybody. To get clarification.
Well, I mean, I guess I can answer from my perspective.
Not a perspective,
Well,
what happened?
well, yes, no questions were asked because it appeared apparent from the letter and our understanding or my understanding of what was submitted. But fair enough, I did not understand there to be any lack of clarity, given.
But your questions today indicate that there was some lack of clarity regarding the application of the ordinance, saying that it lists out this, but not the full ordinance. And you were seeking clarity of what
Well,
part is non-conforming. That's why I wanted to find out, was there questions to the building inspector for the denial or to the planning commission? Or not, sorry. I know Doug from the planning commission, but from the planner regarding the denial letter of why.
no, well, we didn't know any of what, that there was questions about whether this deck was actually going to be a side yard setback, because none of that was cited as a reason. You know,
No clarification was asked.
no clarification was asked, and that's very obviously hindsight, maybe. If we thought there could be other reasons, we might have asked, but given the circumstances. But when Mr. Kinsler gave directions for a permit application he filed to not have any additional zoning violations, to stay basically in the same footprint, and it gets denied on this basis, it seemed apparent that it was an error of law, not that there were a whole list of other things that we didn't know about.
Well, I would point out what he said, those are ingress, egress, get into the houses, and if you read your code, those are allowable. They are allowable.
I'm not questioning if they're allowable. I'm questioning, did you ask for clarification regarding why is it being denied underneath this area? To get clarification regarding that point.
I've done open records requests, no one responds to me, I mean, in candidness, it would be a moot point.
Well,
Be a moot point, just so you know.
Okay.
That's the reason
Was there
why.
any clarification asked? And this is first to Mike, right?
Yes.
Regarding the January 13th letter and denial.
No.
Doug,
You restate the question.
were there any questions asked from the applicant regarding the denial letter from January 13th? For clarification? No.
We would stipulate there was. I don't need to ask everybody, but yeah, there,
Well,
it seemed clear enough,
okay.
yeah.
Questions?
Was the 2020 issue permit was the issue of the 2020 permit raised in the restraining order litigated in front of Judge Stickler?
I've reviewed that hearing transcript. I believe it's mentioned somewhere, if I recall, as history, but I don't think that was ever talked about.
Was the FOIA request?
I don't recall.
Did Mr. Kinsler take any steps to respond to the 3 emails received regarding the 2022 permit, notifying him that inspections were past due?
No, I did not.
Would it be reasonable that Mr. Kinsler had a duty to act upon the warnings that his permit may expire?
But the permit was going to expire, and I think you heard the testimony, there were extraordinary circumstances for why the permits were going to expire. And I didn't, George, you know, what was the date of the issuance of the permit?
I think you said March of 2020.
I gave you guys the letter to lease, so you actually have it in slate. There we go. 3/18/2020 is when the check was written, that sound right?
Okay, so the permit, the 2020 permit
I'll
was
take
then
that, sure.
expired and yeah. March of 2022, and
Wasn't the December of 21?
Haven't the city and Mr. Kinsler gone around and around in, even in appeals? And it was discussed, the reasonableness of the raise order was part of that appeal.
that's the issue,
Right.
is whether the raise order is reasonable. And given the condition, I mean, you've seen the condition of the structure, there's no question that's very little of that structure can be salvaged. But we're looking to reconstruct the house, not repair the house. It is unreasonable to repair that structure, and that has been judicially determined. We are disputing that. We are seeking to reconstruct.
I just want to clarify one thing. So tab 3 does have the full transcript from the hearing. And I did a quick search because I can tell you sitting here today, this is the first time I've heard that there was a permit issued in 2020. And I did a quick search. There's no reference of that. Having litigated this for 4 years, I can tell you this is the first time I'm hearing that. So just answering that clarification question.
Yeah, well, she just serves as probably true. My recollection is that if it was mentioned, it was not a prominent issue in the case.
Is any party contesting the legality of the raise order at this point?
No, I think that's settled law, that the raise order is legal.
So if there's a valid raise order, how does the building inspector get around 175-8 sub E?
Because
Where there's a lawful order of the court that he has to
No,
follow and he can't issue a permit.
well, that's the error. The court is not ordering the raise. The court merely determined that the raise order is reasonable, that the city may raise. That does not remove the discretion of the building inspector.
Are we splitting hairs to say that the court didn't order a raise but affirmed the city's raise order?
Well, it's a.
Is it a distinction that doesn't really have a meaning?
No, it's a nuance, but I do think it has a meaning. I think the issue before the court is different than what is before this body. At the time, the building inspector is asserting that the raise order is reasonable. The court agreed. The court decided not to substitute the court's judgment on that. Well, it found that the evidence was such that the raise order was reasonable. We aren't challenging that aspect of it.
Is the court allowed to substitute its judgment for the city's judgment of the raise order? Is it whether it's simply asked to figure out and determine whether or not the raise order was reasonable, yes or no?
I don't believe the court on the review of a raise order has the same degree of latitude that this body does. This body sits in, essentially could make the same decision as the building inspector. The building inspector in this instance, even after having gone and gotten the court's ruling, could have said, yeah, this will get rid of this junky old house and we'll have a nice new house right on the spot. I'm going to approve this, and not gone forward with the full extent of the raise order. That could have happened. That is within the building inspector's power, and therefore it is within this body's power.
And I think one of the fundamental questions we're asked here is whether or not we have the authority to override the raise order that's been affirmed by the circuit court. And then affirmed a second time by the appellate court. And then if we can do that, can we order? If there is a raise order, can we agree that there's partial compliance with the raise order?
I think
That wasn't really, that was an open, trying to define the issue that I'm seeing.
So I just want to point out a couple of things. Number one is with respect to the raise order that was issued. In the in the statute regarding raise orders. It talks about, because I think one of the arguments that's been made here and that's been presented as well. The raise order doesn't mandate that the city go in and raise the property, okay? And the statute does say may, the order says may. And I mean, I would posit that there's a really good reason from a municipal side why municipalities are not subsequently mandated to raise a property that an owner has been ordered to raise, okay? Mr. Kinsler was ordered to raise the property. The municipality has the power to raise that property. It is acting upon that power. But if for some reason a municipality, I don't know, gets delayed for 2 years in trying to raise the property, somebody gets injured, I can tell you that you'll now have a ministerial duty that the city had that it violated to raise the order, or to, excuse me, to raise the property. And then the city becomes liable for failing to effectuate that ministerial duty. So I would posit that the legislature probably put in May that because it doesn't want to mandate the city to do that. However, the city does have the power to do that. Okay, there is an order in effect to raise that the applicant has failed to effectuate, and now the city is taking that responsibility on to get rid of a property that is dilapidated and out of commission and unsafe and uninhabitable. And to the question about a partial raise, raise is again a defined term. It is dust-free, erosion-free condition. And I would also advise that if a raise order is deemed to be unreasonable under the statute, the municipality can take no further action unless substantial change happens. So arguably, once substantial change or any kind of change to the property happens, the raise order is null and void because the property condition has changed. So if a partial raise or a partial demolition were approved, which is not in compliance with the full order to raise, and demolition just stops. Maybe they take down the second floor and they don't do anything else and it just sits there. The raise order is not in effect. The city would have to go back to court, obtain a new raise order. That will have to go through all the appellate process, which as you saw in this case, took 2.5 years. And the property will continue to sit in an unsafe, unsecure condition that it's in.
I think your question gets back to the question I asked at the beginning of whether you were asking us to overrule the courts on the raise order. And the point I was getting at was, I think this body could issue a permit for partial demolition. But that doesn't stop the city from coming in and demolishing the rest of it. The raise order is still there. The city still has the power to do that. And in fact, I don't know what would happen if both permits were issued. The house was built, but the raise order is still sitting out there. The property never having been raised. I mean, it's a very unusual situation.
Well, I agree, it's an unusual situation. I mean, you know, to the extent we're concerned about, whether we would go through with it. I mean, I think there are things that the board can do to order what ought to be done. There can be, well, I mean, there can be financial security put up to be sure that if it gets forfeited, we'll go ahead and do it. The note I've been passed is, see, there's an authorization to deposit in the trust account funds to secure that. I think you could put a time frame on which this would have to occur, that the building would be down and construction would have to commence. And still preserve the raise order, so the city would not have to go back in and restart the process.
So I don't know where that is in the ordinances. So I agree that the board has the same powers and responsibilities, they have the same powers as the building inspector. So I would like to know where the authority is for them to impose that. Because under the code, it just says that the building inspector, if it complies with the code and it complies with the law, it shall issue the permit.
Right.
So the permit as applied for does not have any of those conditions.
No, but the board can impose conditions that I'll read the statute again.
Well, that talks
That-
about all of the powers that the building inspector
Right.
has. So if the building inspector has those powers, the board has those powers. So I'm asking where the building inspector has those powers.
Well, the building, yeah, the building inspector would not have the power to require some kind of security put up, but that is something that is being offered up as something additional for the board to consider. But I think the building inspector would have the authority to allow the permit to issue and the demolition permit to issue, and if construction does not occur, he has the raise order in place.
So I think there's pretty clearly two distinct issues in that these have been getting rejected both times, in that issue one is that the plans as issued are not the footprint, right? I mean, that's debated, whatever, I mean, but that's issue one. And if, you know, I haven't been on this board terribly long, but if those plans were brought for a legal non-conforming structure, we would probably reject the plans and say, you got to bring plans that don't increase the footprint or change the setback or whatever. So that's issue one. And that would be sort of a, you know, here's how you can change to make this work. Issue two is obviously the raise order. So the concern I have with that is obviously that's a different statute under which the building inspector has to reject if there is a standing order in place. And that is, could somebody remind me of what that is? 175 something?
-8 sub E.
Hang on. Because the concern there is that the building so I guess the issue with that is that that seems like a very black or white issue from the building inspector's perspective, which is if the building inspector finds that the proposed building will comply with all lawful orders of the city and the state, he will officially approve. But it objectively will not, because there's an existing order to raise the building, which is again a legal defined term, which tear it all down, restore it to greenfield site. So to me, issue A, I think the board would have like a conversation about and be able to deal with. Issue B seems very black or white to me and is an issue with getting the city to rescind the raise order to permit you to do this.
Well, it's not an issue of getting the city to rescind it. And I mean, I understand that you're reading that, but what is unique at this position, it is not the city's, or it is the building inspector's order. It is an order issued by the building inspector.
But it's an order he has to issue. He doesn't, it's not a.
Well, he could have decided not to go there and issue or he could have modified it, or, I mean.
Okay, I mean, am I allowed to ask? Okay. I mean, is that when you go to a building and, I mean, and you find it dilapidated, whatever, there's the 50% rule where it's 50% the value of the home today would cost to repair it, then it's, you issue a raise order. Do you have discretion in any of those steps?
I mean, certainly I'm not the all being as the building inspector. There's other considerations, the city. I mean, we work for the city. So these decisions are not just made solely by me. Does that make sense?
Yeah, I'm just trying to determine how much judgment is permitted, and I'm not talking about dollar values, like,
Sure.
I think everyone's pretty clear that that repair would exceed the cost of the value of the home right now, but how much discretion or judgment there is in whether or not to issue a raise order.
I guess when I do it, I look at it, from the perspective of when I was tasked with this, what is the condition?
Mhm.
At the statutory conditions, it was, uninhabitable.
Right.
Old, dilapidated, unsafe, unsanitary, et cetera. And it also met the statutory threshold for the municipality to order it raised.
Okay, so do you issue that order or does the city?
It's, I guess I would say I sign it, I issue it on behalf of the city.
Are you able to, I mean, if you made those same exact determinations and for some reason you were feeling extra generous that day and you just said, I'm not gonna issue this raise order. Is that something you can do? Is that something within your purview or judgment to do?
I guess I would say. In my opinion, no, I'm following the directive of, of the statute of the rules. I guess I would be going against that.
I think that's, and I'd be interested in your opinion on this too. That to me is the issue, is that this feels like the raise order feels like a very yes or no thing and would need to be withdrawn for the building inspector or this board to be able to, like, we can't withdraw the raise order. And the raise order is a black and white issue as far as whether this can proceed.
Please. Been thinking about the point that was made about the city didn't issue the order, the building inspector did. Sir, you're contracted by the city?
Yeah,
correct.
You work for the city?
Yes.
You operate under presumed authority of the city? I mean, I would argue that he's operating under color of law. The order is issued, state of Wisconsin, city of Monona, Dane County.
I would
Order to
also
raise
just,
building.
point out though that the circuit court order that was issued not only affirms the reasonableness, but it states that the court finds that the respondent complied with the statute and that the city may enter upon the property to raise the building as defined in Wisconsin statute through any available agency. So the circuit court order that was issued
Right.
also has the same language with regards to the property or the city going onto the property, the city raising the property, charging the full cost as pursuant to the statute, that the petitioners need to vacate the property, they need to remove all personal property. That's all within the court order. So to the extent there's any question about it being a lawful order of
No,
city or
not at all.
And then with respect to the applications, like, I think we've heard some testimony about how they're incomplete. And, if we can take the action that the inspector can take, we can also deny the application and deny the request because the application is incomplete. It doesn't list some very material contractors. We've heard testimony about how we're not quite sure whether or not it does in fact, although it does appear to me that it may extend, enlarge, reconstruct or structurally alter the property. And it might even additionally encroach upon the property in violation of 480-40, and we're not here for a variance. That would be a separate issue that we're not here for today. And we don't have to proceed under just the letter, the letter, I don't think either.
Well, I guess what I'm trying to do is. Maybe this is outside the scope of what I'm supposed to do, but provide you all a path.
May I speak
I mean-
to council for a minute?
Of course.
Is that okay?
That's okay with.
Do you want to step out? I mean,
Always out there.
yeah. Do you mind if we keep chatting or do you want us to wait? I you probably want us to wait.
We can.
Yeah, wait.
Yes.
I answered my own question as soon as I had.
Good job.
Has to be open meetings requirements.
It's the same old rough.
There's another one. I'm on the tail end.
My question is, isn't the grandfather going to consider? Based on what you said earlier. The first statement that you said. in the beginning.
so Doug, I'm not gonna have you make any questions.
That's what it's.
I'm sorry?
Wasn't speaking to. Clearly, everyone is openly speaking out, asking me questions.
Certainly not that, right?
Well, no, but my point is if this is a condemned property, why does it have a break and improved value?
That's over. Right. Yeah.
Right. Yeah, I mean, well, at this point, I think, I did want to point out. The back of the building permit application, Mr. Kinsler's acting as the general contractor. There are contractors listed there to do, the subcontracting, work, electric, heating, et cetera. Packet, this was the building permit packet.
12, or sorry, 10. 10 and 13 are the applications.
Any other information? No additional information. I think the frustrating thing from my perspective, as I piece together the history of this, is it seems like there is not a lot of good communication that's gone on between my client and the city. We had a building permit out there that was approved. For the reasons why he was unable to go through with it at the time. Got evidence that he was told, hey, the building permit's expiring, but until you get a raise order, that doesn't really tell him that, listen, X, Y, and Z have to be done soon, otherwise we're gonna issue this raise order. Or if you don't renew your building permit, you're going to get a raise order. Go through this whole process, 2 years, 3 years of litigation. All talking about whether or not the raise order is reasonable. But never really getting down to what is the solution here, what can be really done. Even he's reapplies for permits and you just get a bare bones. Well, it's because it's non-conforming, of course.
we look at it and say, well, we thought we did it, and that's not what the ordinance says. Now, granted, no, and I realize maybe there's other questions, to be answered, but what we're seeking to have done here is justice and come to a determination as ought to be made. Like that, statute, that's what I meant for a long time. So, yeah, I mean, I don't know if things would have been different in it all from the very get-go, but it seems to me that, the right thing, the right outcome here, is still right despite all the frustrations and the miscommunications and the lack of understanding that's gone on here.
Yeah, I guess, I get the sense that there's a lot of frustration in the room, and that's why, like, what I was trying to do, and again, I don't know what my, if I'm speaking out of turn, I'm assuming somebody will stop me. Okay, but what I was trying to do before you all stepped out was identify a path to resolve the two different issues, because I think the first issue is a resolvable issue. New plans, better understanding, and I know Doug more than willing to work with people to get those types of issues straightened out. The second issue, I don't know what to do about, because to me, in order for a building inspector to issue a permit to build, the raise order has to either be complied with, which it wouldn't be, will be rescinded. And I don't know how that part I don't know what to do or how to handle it.
Well, and I understand, as a practical matter, I'm also a contractor. I'm the city attorney for Middleton and down there. And so, I know that there are a lot of statutes that say the city attorney can do this, that, and the other thing. And I know, just like Mr. Parrott being contracted, that, you have to make your own independent choices and stuff, but you are also serving a client. And from that perspective, I understand that, he is not, as a practical matter, entirely independent. Statutorily, however, the statute puts the discretion in the hands of the building inspector. And when we're talking about the legal powers of this body, I think those legal powers still reside with this body, even if Mr. Parrott has some practical constraints as an outside contractor and being employed by a city. I understand that's another pretty nuanced distinction, but I do think is an important one from the perspective of what is this body's power. And I don't think that the practical constraints of Mr. Parrott's contractual relationship with the city change those statutory dynamics.
Other questions from the group?
I have one, if not, just to clarify, anybody from any witness on the applicant side, or Mr. Fleming, if you know, in the building permit application for the construction, is there any drawing or document or statement or anything that says that the new building will be constructed within the same footprint as the existing building, or otherwise that it would not violate setback requirements? Any new setback requirement? I'm looking at the drawings under tab 11. I see a lot of numbers in some very small print. I don't see anything that suggests that it would. And my question is, am I missing something?
Well, we're just messing with that. You break these like that, aren't you? George, if you know, feel free.
Yeah, I'm looking at for you, sir. In their standard form, it asks the question, do you need a variance, blah, 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 blah.
Well, and what Mr. Kim was looking at, that's one of the other troubling things here, and again, had other questions been asked? I mean, have there been discussions after we applied, or further discussions after we applied for this permit? You know, I showed up here tonight because we were told that you can't reconstruct a legal non-conforming use, basically, is what I read that to say. And I believe that to be clearly contrary to the law, but now I show up and find out that, oh, I guess these other things could be an issue. Would we have applied for a different permit? You know, I didn't ask those specific questions. I did have one brief conversation with Attorney Cole. I'm not throwing him under the bus, because it wasn't like I was asking questions, although, you know, we did kind of throw out, you know, is there a way to go forward, and he seemed to think not. So you know, to that extent, I guess there was some communication, but, you know, so we've come here just completely unprepared to talk about the ingress egress issue. Mr. Kinsler has stated that it's his belief that when this was designed, that there is provisions in the zoning code that make exceptions for setbacks with regard to the ingress egress things, and that's what's being done here. First I've ever heard, so I apologize, I don't have the ability to counter that.
The reason I'm asking the question is that the Monona ordinances require a plot plan showing the location of the buildings in relation to lot lines and other things. And I'm just wondering if any of this even arguably complies with that. Yeah, and if it's in here, I'm just.
I think the only lot line on there is the meander line for the lake. There's no,
Right.
red line or, side yard.
So, Matt, just share this with him. Because this shows where the property is in relation to the side yards. It's a big picture.
Well, but was this submitted with the building?
Hold on a second. And the building is going to be placed right on that foundation. We don't need erosion control. We're not moving any dirt. Okay? If in an amended application, if Mr. Plowman thinks that they need tubes put around in case someone digs a shovel hole, okay, but it's not necessary because we're building right on top of that foundation there. There's somewhere in your permit process where you check a box that you need variances, don't need variances, and that box was checked on the application. I've known I've done this application here. I can't show you where it is on this corner, but so that particular application said that there was, we wouldn't be asking for any variances. It's like there's now a change in impervious surface, the building on the same footprint. Our intention is to cure the situation and the problem. That's the intention.
Understood.
You know, and I mean, and we can perform this, but we need some document the council provides, that's approved by the city. It says, okay. I mean, the city's had over 90 days since the stay to do the demolition. They haven't because it takes time. You need to get bids, and I had a bid. Had a guy that was gonna do it in February, okay? When everything was frozen, Cruz Roofing was gonna go in there and take it right down to the floor deck. That's what the demo permit was for. It's ready to go. I can't do it now because it's not frozen. So it's a different animal, you know? When it was frozen, it was ideal, and that's why we did what we did to try to get it done. It was $10,000. And at this point, it's gonna cost more, but we can do it. We can get it done, given enough time. 90 days at the most, and we'll put up, if Fritz thinks he can do it for 30,000, we'll put up 30,000 in trust account. If we don't get it done, Ms. Tierney can have the money and give it to the city of Monona. it's kind of a reasonable way to go it, and we'll fix the permit to make Mr. Baumann think we're in compliance. That's what we're asking you to do.
I understand. I want to try to address this as straightforwardly as I can. And I'd like to ask you, Mr. Pear, to weigh in if you agree or disagree, if that's okay with you. If you were to submit a brand new building application with detailed plans, setbacks, survey, no grading to be done, et cetera, et cetera, et cetera. As far as 480-40A, my guess is that you would not object to that. It was on the identical footprint. There weren't the new catwalks or the decks on the sides, all the kind of stuff that had raised your concerns before.
You're asking about just its compliance with 480?
Just the compliance with 480.
Yeah.
But I'm assuming that it would still be rejected because you're still not complying with a legal order from the state, from the city, which would be the order to raise it. And by raise it, it means like essentially return it to a grass plot of land. So those are the two separate issues. So I think one issue is you submit those new plans, the really detailed ones that ensure it's on the same footprint. The second one is the one I don't understand how to deal with. Because I don't know how to give you a next step on that one, because to me, as far as my read of the statute is, the city would have to rescind the raise order, or somehow you'd have to work with the city to get them to pull that back and agree with you that your plan makes sense. But that I don't know how to resolve.
Well, as I said, that's what I got back to with my argument. I believe statutorily it's still the building inspector's order, which therefore gives you the power to do that. Like I said, I fully understand.
Are you
Mr.
talking
Pear.
like the raise order is his order?
The raise order is,
So you're saying that
building
they have the
inspector's
ability
order.
to rescind the raise order, because that's just patently wrong.
well, I believe I believe the building inspector has that authority. No,
But the raise order is not at issue, as we've discussed, it's not at issue, it's in effect. And he challenged the
Well-
reasonableness, and under the statute, that is his sole recourse for challenging the raise order. He's exhausted that. The raise order is in effect.
And before he gets the raise order, he has to get that special inspection warrant, correct?
It depends on
Like
the
he
circumstances.
testified, he got a special inspection warrant to go and enter the house.
Yes,
And in order to do that, there has to be some notice to the landowner.
yeah, it was through, and that
And so
admittedly
before
predated.
we even get to the raise order, the landowner gets notice that the city's gonna come in and they're trying to figure out whether or not what we need to do with this property because we have a dilapidated property. I mean, that's the time you jump up and down and say, hey, look, I had a 2020 construction permit, it lapsed because of COVID. Give me 90 days.
And admittedly, we didn't go through the full exhaustive history of this property, but it's extensive and dates back at least 10 years.
Yes, sir.
So it's not as if Monona just came barreling in saying, hey, here's a raise order. There was no notice that this could potentially be an issue. And you saw photos of the property. It's not like it just gets like that overnight.
Mr. Chairman. Could you show me a copy of a citation or a fine or a notice from the city on this property, other than this raise order?
Well, here's where I think we're taking off
So-
no reads in this.
so-
We're
so-
just, it's a bunch of red herring.
Yeah.
So
We have a raise
No,
order.
no.
So
No,
I wanted to
No.
answer his
Hang on.
question. I
We're,
have-
we're here for a simple question on, are we upholding or changing the denial?
I wanna make a motion.
And we've heard a ton.
I'm gonna make a motion to uphold the inspector's denial based upon the raise order, which is a lawful order that is not in dispute. Notwithstanding that, even if there was no raise order, I think the application would likely still be rejected because of the deficiencies in the application that were discussed, including the deficiencies with the home not having clearly shown the setbacks within the boundaries of the property. So I think there's additional issues there as well. And I think additionally that it arguably would still, even if there was not a raise order, additionally encroach into the zoning regulation impermissibly under 480-40. So for those reasons, I would move to uphold the inspector's denial.
there a second?
Second.
Any further questions or?
Can I ask a question?
Hang on.
Sorry.
I'm not sure if they were better before or after. I guess two questions. One, the raise order. Does, if we were to approve or rescind the building inspector's denial, does that alleviate the obligation of the property owner to raise the property under the raise order?
Yes.
It alleviates that then?
Yes.
Well, hang on. Say that again.
The court said that the raise order is reasonable.
Yep, move forward.
And, right, and along with that, basically repairs are not reasonable. So asking to repair is probably not considered reasonable because it's already been declared unreasonable. But it upheld the raise order, which puts both the property owner and the city has a permissible responsibility, the property owner has a responsibility. Just because we allow the building to go up, does that leave the property owner of the responsibility to raise the property?
But at this point, I don't think the property owner has an obligation to raise it. I think the city has the authority. His opportunity to do it expired under the terms of the raise order.
Okay.
His obligation is to get his stuff out and not interfere with the raising process.
That's another question I had, is the order to vacate. Can you build on the property that you've been ordered to vacate?
You're talking about the court order? Yeah, I think the court order was intended to vacate the property so that the building can be raised. After that, the city's not taking the property, the city is just cleaning it up. It's under the raise order. And what happens after that, it's still his property. He can still apply for whatever building permits are allowable under the ordinances.
But to be clear, we're not asking to repair, we're asking to construct.
Well,
Building permit asked to repair.
that's a matter of definition because
Yeah.
what you're asking to do is reconstruct part of the building.
Well,
You're not putting up a new building.
I, fair point.
I think it's important because, once a raise order has been issued, you don't have, or once the court upholds raise order and determines that repairs are unreasonable, you don't have the option anymore of repairing.
Well, again, well, is this a repair? And then I would argue, no, it's not a repair. That's.
All right, any further questions from the group? We have a motion, we have a second. You had a comment.
I had a question.
Well,
Well, I have a question.
we'll see if we can answer it.
So. Given a certain amount of time and a deposit. You can, I think, say that we could take responsibility for the raise. If, because you're in charge, so you could do that if you determine that. Second part is, no matter what's raised, does the tunnel and the boathouse, they're auxiliary parts. Do they have to go? And if they're raising. I mean, I was the initial member on the sustainability committee in the city of Monona. To pull out all that concrete and pull out that whole basement and send it to the landfill. Turn around and have Lycon bring it all back. Seems counter to what we want to do and stand for. So that's my commentary. Now, that doesn't impact your vote, but I mean, help us. Let's make this right. Let's make this look good. People are gonna wonder, what does this all mean? You fix it, let us give us the time to get it fixed. Don't give me 30 days. And here's your notice. And by the way, this is a Friday. Give us enough time. We'll get it out of there. If that's what you want. If you want the basement out of there, I guess so. I can have a backhoe just like mine holds. But if I turn around and put it back in, do I get to put it back in the same place? Or are you gonna set me back 25 feet? That's walking out of here tonight, I need to know, if I came to you guys in an appeal, am I moving back 25 feet or can I reconstruct in the same location again, after I tear this basement out, that I'm gonna put a new one in?
My
Because I'd like to
understanding,
know.
if we uphold the building inspector's decision, the building will go away. You would then file for a new permit, new building permit, and that would be subject to code as of today.
So I'd be set back.
Correct.
And what about the tunnel?
Doug, can you speak to that?
My understanding is that is part of the court order. It's all improvements, which would include the boathouse.
And the driveway?
I believe so.
So you're gonna grind up the driveway, basement, the tunnel, and the boathouse and send it to a landfill. That's good for the
Well,
public.
you could look to see what was on the RFP.
So to raise a building under the statute quote, means to demolish and remove the building and to restore the site to a dust-free and erosion-free condition. So.
Which may or may not.
How does that serve the public?
Because the driveway.
But, yeah, we're not here to
Yeah,
discuss
yeah,
that.
okay.
Like, our job and task is very narrow.
Yeah, no, I appreciate your courtesy.
I understand.
You're not.
I think part of the problem with some of these cases is that they do have a deep history, but sometimes our view of it has to be very narrow. Oftentimes when we get people in here and it's not that the board disagrees with their plan. Most people come in with a pretty good plan, just we can't always approve a variance or approve what they want to do for one reason or another because we're confined to our role and what we have to look at.
If this ends up in a denial, and maybe you can't, neither of you can answer this, I don't know, but is there any way to stop the city from raising the? Is it a 100% guarantee that that is going to happen, or is there a opportunity for them to discuss that and negotiate that? And that, like, that's what I'm having the biggest issue with, is that, again, if you bring great plans next time, like, we'll take a look. But the reason that it will get denied again anyway is because of the raise order and that it has not been complied with. And so if there's any way to rescind that, working with the city would be the next step that I would, like, that's what I'm trying to get to as like the threshold issue before anything else happens, is that has to be figured out.
So that would be a question for kind of the higher ups of the city to decide whether or not they would want to enter into some kind of settlement agreement where they would voluntarily rescind the raise order. And I can't speak to that. I don't know that Mr. Plowman can speak to that. That would be a decision by the city because the raise order is in effect.
Understood.
That's-
Yeah, I mean, that's what I can't get past. And that's what, like, I think I'm trying to give you a next step on the plans and a next step on the raise order, and the raise order is way outside of my purview.
Well, I think that the
So-
next steps on the raise order have already happened, right? The next step on a raise order is to challenge the raise order. That was what the TRO
No, I know.
was, and
But I'm trying to, I mean, I realize that.
like a workaround.
The
like a settlement,
procedural, yeah, the procedural next steps have been taken, but there's got to be something else, right? And so that's what I'm trying to propose is if you get that figured out, like, again, I think there's a path to get where you're going here.
I think it's
Okay.
entirely, as I sit down again, maybe I'll come up with some other brilliant ideas. I'd like to think I'm capable. As far as I sit here right now, if our appeal is denied, we are at the mercy of the city to be willing to discuss some alternative. And it would be entirely discretionary on the city's part.
But to your question, they can resolve it in any way they want to resolve.
So can this board give them a friendly motion that says that they would appreciate that they would cooperate with council?
We can't do it.
You can't do that?
We're here to say yes or no to his denial letter. The piece about you approaching the city and stipulating something to the agreement, that's not us.
You're a member of the council.
That's me with a different hat on, but that's not us.
Okay,
Us tonight is the motion that's on the floor, and the second, which is to uphold the denial letters. What happens after here, you have a nice member offer at least some suggestions about where you could go. Although the end of the roadway is becoming quick. And so it seems like there is possible one last stop on that road, but it's not what this body after the decision.
So who do you suggest that Mr. Fleming's supposed to be talking to? That would be effective and expedient.
We could probably share that after this meeting.
Great, that'd be
Yeah.
super.
Alright. So there's a motion on the floor, there's a second, any further questions or comments or discussion? In the group? Anything I missed before I call a vote? Okay, all those in favor of the motion, say aye. Aye. Opposed? Abstained? Motion passes. So it's upheld.
Did you abstain or are you calling for abstentions?
No, I call for abstentions, but there are none.
Okay, I
Yes.
didn't know if you were
Yeah,
saying you
no,
abstained.
I was just making sure, because I got a cold, can't hear everybody. So number 7 is, we're not going into closed session, and so number 7 and 8 go away. Number 9 goes away, number 10. Next meeting is April 17th and May 15th, so just to know those. Any updates from the group regarding DEI efforts or sustainability efforts?
Thanks a lot, Ben. Appreciate it.
Okay, we can close item 10, we go on to item 11, so we just want a motion for adjournment.
We may.
Another second. All those in favor say aye. Aye. Opposed? All right. You adjourn.
Where do my phone go? Let me see that.